house for $450,000, which was the agreed upon price. That's one of the things that they're asking for, that this matter be completed. Now, there are issues because the interest rate in the summer of 22 was different than the interest rate now, but he wants me to order you to sell him the house at the agreed upon price. In fact, that may be the primary thing that he wants. There's also a dispute. The defendant claims that he paid, I calculated about $115,000, $85,000 in cash, and then some subsequent payments and some $2,000 a month payments, and then I've ordered escrow. So they're claiming they've paid about $115,000. They claim that $85,000 was given to you. In your pleadings, Mr. Hauser claims she never got the $85,000.
I didn't get all of $85,000, and he was supposed to pay me $4,000 a month. $4,000 a month for 12 months is $48,000.
Now, it does not say that in the lease agreement. It says the amount.
It says zero.
It says zero.
Exactly. I didn't draw up the lease agreement, Your Honor.
Well, you didn't draw it up, but you signed it.
Judge, I'm just gonna object to the extent that this is part of the hearing to any testimony, I mean, if we want to.
Yeah, well, she's not under oath,
Okay,
and we're not
I
taking
just-
testimony,
okay,
but,
okay.
and she's also a layperson doing the best she can, but she bought a firestorm, she fired her lawyer, and you're here ready to go. And they've got pictures here, they've got exhibits. There's a picture of you sitting here with a great big pile of green cash. None of this is in evidence yet. I'm interested to know what it's about. They've got charts and graphs, and they're prepared to present evidence on how much money they paid you.
I can't defend myself today, Your Honor. I just can't.
Yes,
You understand?
I do understand, but you caused this problem.
I
You
didn't-
fired your lawyer the day before the
I
hearing.
didn't fire.
All right, well, anyway, whatever happened, the relationship broke down to the extent, and what you told me is you no longer wanted him as your lawyer. So I don't know how that came to an end, but he's not here. And so Mr. Hauser, Mr. Hatch is chomping at the bit to show me all these exhibits.
Well, I can't defend myself today. I cannot.
Yes,
You understand that?
I do understand it, and I don't want to do it twice, and I don't want to appeal it. But you caused this.
I didn't cause it.
Um,
I'm sorry, I didn't cause it. I have to say it how it is.
all right, well, all right, that's your position, and so I'll respect that.
I never
But-
caused it the first time around, Your Honor.
All right, well, obviously they have an opposite view of it. But anyway, the fact that your lawyer filed a motion to withdraw yesterday at 2:30, you're not blameless in that.
I didn't.
So, and they're saying, look, we took the day off work. We came over here. Our lawyer's here. He's on the clock. We're paying him. We have witnesses here that we're under subpoena, and that's not fair to us. So it'll be an issue regarding costs, but
How can I call these witnesses for me? I don't know.
no, I agree. You're not, I'm not being insulting or condescending. You're not qualified to represent yourself in this hearing.
Right,
It's complicated. There's a lot of money at stake.
right,
There are rules of evidence, rules of procedure,
right.
that are going to apply. And you can't represent yourself. So I could let them go and present everything. And then you could hire a lawyer that would move to set all that aside because you weren't
I don't
qualified.
want to have them do it and hire a lawyer to set it aside. I want to wait till I have my lawyer here. I thought that Matthew Hauser was going to stay here today when we were going to have this. I had no idea what was happening, Your Honor.
Well, no, that leaves him in an untenable position that he's representing you on something where you don't want him to be, and then he could get grieved for it.
I had no idea of any of this until 7:30 on Wednesday night.
All right. I'm also advised that you failed to appear for your deposition.
I was very sick. I had bronchitis.
All right,
and was-
well, there's a dispute as to that, and I didn't give you permission to not appear. It was a subpoena, which was an order from the court to appear.
you know,
And so I have people call up every day and say, well, I didn't feel like coming in today. I didn't feel good.
no, I had a doctor's.
Yeah, I know. And they're talked about the doctor's slip. There are two different signatures, and there was a first letter and a second letter. And so they're suspicious of your doctor's letter. But at any rate, you didn't show up and the deposition wasn't accomplished. And so that'll be an issue that may have to be addressed. Anyway, all of this is expensive.
Are you telling me?
Yeah, I'd hate to see what the legal fees are in all of this before we're finished. And I'm cognizant of that. I'm trying not to run the bill up for each side. But I can't do it, Mr. Hatch. That's fraught with too many problems. You're a fine lawyer. You've got lots of exhibits, lots of rules of evidence, foundational things, people under oath, examination, cross-examination. I can't proceed.
Your Honor, if I may just respond very quickly. Today's hearing is, I would call Joe O'Donnell to testify regarding a lot of the payments that were made between Mr. O'Donnell and Miss Blair, along with the factual underlying basis for the land contract. That we're not going to testify about real damages here today because we don't have enough time. I will lay the proper foundation, which is subject to me to avoid an appeal for that. Miss Blair chose to fire her lawyer at the beginning of this hearing. I heard you ask the appropriate questions. And now she claims that she cries wolf, I'm unrepresented. She chose that today. I know Bob O'Brien from Miller Johnson in Grand Rapids, and I would be shocked if he didn't call me yesterday and say, I'm representing Miss Blair. I'm about to represent Miss Blair. Here are some dates that we have available. So if we want to get Bob O'Brien on the phone to see if he's representing Miss Blair, to see if there's an engagement agreement between them. But this is the third time we've been here, and I'm cognizant that the court does not want to create an appealable issue. What we would be going through today would just be documentary evidence underlying the factual legal positions and not anything regarding damages or any conversations outside of what happened between Miss Blair, Mr. O'Donnell, and Miss Bowers. It's as simple as laying a foundation, admitting the evidence, and we can stipulate, and the judge can, if there's not a proper foundation, then you can rule there's not, but I'll lay a proper foundation and we go forward today. And then we can have another hearing that I'm sure based on the court's calendar is going to be probably a month out because you're very busy. Miss Blair can find a representative during that time and he can come to a hearing, he can represent her. She's not calling any witnesses today. I'm just calling Mr. O'Donnell, and it's a couple hours, Your Honor. So I would respectfully ask the court if we could just at least get a couple hours out of the way today and admit some basic documents.
Thank you. It was very well stated, and I understood everything that you just said, but I don't think she did. What you're proposing, it makes sense to a lawyer. I don't want to buy a redo on this, and so I don't have to like it, but she's not gonna even know what we're talking about, laying a foundation and evidentiary hearing. She doesn't understand what you just said, and that's not a criticism. She's not an attorney, so I don't think I have any choice. Now, I had strongly encouraged the parties to settle this case. And Mr. Hatch and Mr. Hauser said they worked diligently on trying to get to a resolution, but they don't get to decide, the parties do. And if it isn't resolved, I will hear it and make a decision. There's a lot of money at stake. They claim they paid you $112,000. Which is close to what I had estimated from the proceedings, from the hearing. Now, this started out as a termination of tenancy case. Ms. Hines was indignant and you were being moved out of your house. They were taking things. And then at the first hearing, Mr. O'Donnell and Ms. Bowers showed up. And I said this in chambers, I didn't realize I had handled the zoning case, which was in your name. And you consented to everything. You called them, asked that the property be inspected and condemned, consented to an order, and stop. We're not in school. You don't have to raise your hand, but I'll give you a chance to say something. And then I hear that they used that to remove the people from the house. It was frightening. She's in bed asleep and the cops come and the zoning people come and they're kicked out and then the doors are locked and then we're here in December and then I get his version, our property's missing. I get this notice to quit. I have this agreement and I said, there's more here than meets the eye. I found that was a violation of the lockout statute. I've never seen it done where the landlord condemns the house that the tenant's in and immediately gets them removed from the house. Anyway, so then we're at that hearing. It's like there's a whole bunch of issues. So Mr. O'Donnell and Ms. Bowers hired Mr. Hatch. You hired Mr. Hauser. Things got adjourned. They got adjourned again. They got adjourned because of a tornado that didn't show up. And finding time to hear this has been very difficult. And let me repeat, I denied your motion to set aside the default or Mr. Hauser's motion. All he did is file a motion without anything more. So that default is in effect. And one of the things in there is a motion for for specific performance, that you sell the house at the agreed upon price. And that's really what this is about. But I'm not going to make you try to defend yourself in this proceeding. She said she talked to Mr. O'Brien. That's different than retaining him or signing an agreement. And he's not inexpensive either.
I'm meeting with him next week. Can I say something, Your Honor?
Yes, you may.
I never had the house condemned. That is an absolute non-truth. Mr. Ard from State Farm, who's a structural engineer.
Your Honor,
Oh, yeah, now we're getting into, you're not under oath.
Okay.
Yes.
I never had the house
Your Honor,
condemned.
I'm going to object again to any of
Well, the
that.
house was condemned.
Not by me. I wasn't even there.
Your Honor,
All right.
I'm going to object to any testimony from Ms.
Well,
Poirier.
she's not under oath. The house got condemned and Officer Kuhlman testified, I believe that you called him and asked to have him come out there and you consented to the order. I'd have to look at the record from the condemnation hearing, but anyway,
I never had the house condemned.
well, the house was condemned and
I had to pay to have it fixed then.
well, you were the owner.
Right. But
Okay.
they said they were the owners.
Well,
That's
they weren't, they were the tenant.
right.
All right,
So-
that's one of the fundamental issues here. So you're not under oath. I don't want to get into it. But,
Right. I
um,
understand, Your Honor. I
but-
don't know what's right and what's wrong to say.
all right, well,
But I do know I did not have the house condemned. And I will tell that to
Your Honor, I'm
anyone
going to
in the
object
world.
again. I mean, I've heard it 5 times here
Yes,
today.
yes.
She's not under oath, and I'll object to any further statements.
well, and she didn't show up for your deposition where you could have asked her those questions under oath. Well, then who did have the house condemned? Did it just show up out of the blue? There was a little bit of damage on the porch, and the next thing you know, they're crawling into the house, looking at how the window was bottle jacked up. So it was not good. Anyway, that's a separate issue. This is a termination of tenancy. And that condemnation, whether you did it or not, was used by you to terminate the tenancy. Mr. Yunker sent them a letter
Right,
and said, we're using the condemnation clause of this agreement to terminate your tenancy. You have to move, that your contract is terminated. So you used it to try to get out of the contract.
I didn't use it to get out of the contract, sir. The attorney said that's how it was. Because they
All right, well,
weren't,
stop. That's what happened. The attorney used the condemnation to attempt to terminate the tenancy. But what really offends me is they were removed immediately without notice from the house.
but they weren't.
Well, I took testimony that they were.
From whom?
From Mr. O'Donnell and Miss Bowers.
They were not.
All right, I don't want to argue
Okay,
with you. She was in bed asleep and they came and they put a condemnation on the house on the 9th of August.
No, it was the 12th of August when it went on in the house.
All right. Well, at any rate,
That I know.
Your Honor, I think that Ms. Blair has alleged capacity issues, but it seems like today she has a very fine memory of the facts of this case. So again, I would just ask that Ms. Blair not testify anything at today's hearing, even if she's not under oath, because number one, a default's been entered.
yes.
So liability's been established. We're here for damages. So again, I would maybe just ask Ms. Blair to
I
listen
don't
to the court.
understand
instead of
any of
And I understand that you don't. So I'm going to grant your adjournment. I don't have to like it, but I'm going
I
to.
don't like it either, sir.
Okay, well, that's.
I don't like it any more than you do.
Well, it's unanimous. Nobody likes it.
Right.
Very intrigued by this picture of you sitting with a large pile of cash, which would seem to support their contention that they gave you a large sum of money. It looks like there's a contract, looks like the lease may be sitting on top of the purchase agreement.
Same time, yes. And you can see how my eyes are. I was sick as a dog and they knew it. I have an aneurysm.
Stop. You
Okay,
can't
I'm
keep
sorry.
testifying.
I'm sorry.
All right.
I don't
And
know
what
what-
I said is, on one hand, you said, well, I didn't have the capacity to enter into this contract. On the other hand, that contract was used to kick them out of the house. So you can't have it both ways. And they were going to present evidence to show that you were competent to sign it. Now, this house, if it went on today's market, would sell for more than $450,000. And that's what's going on here. But there was a signed, notarized purchase agreement to sell it at that price. As Mr. Hatch indicated, I have a hard time finding large blocks of time, particularly in the summer. Judge Patterson's going to be gone. I'm going to be gone. There are judicial conferences. I have a million things set. So finding a spot to put it is problematic. I'm going to continue this matter for the damage hearing for Wednesday, June 28th at 8:30.
When fear takes the wheel, bad decisions follow. And this case proved exactly that. A routine street stop. Officers investigating an incident in the area approached a man and his significant other simply walking home from a gas station. No charges, no crime, just a conversation. But for this defendant, that moment of contact with law enforcement triggered something primal. Panic. Instead of giving his real name, he handed over the identity of a friend. Mario Arredondo, an innocent man, became his shield against a felony warrant he was trying to outrun. The judge didn't mince words. That wasn't just a bad decision. It was a selfish one, the kind that could have sent an innocent person into the system in someone else's place. To his credit, the defendant owned it. He admitted he wasn't thinking clearly, that fear drove him to betray someone he called a friend, and that Mario, understandably, wants nothing to do with him now. What makes this case cut deep isn't the charge itself. It's the collateral damage of one cowardly moment. A friendship destroyed. A man's name used as a throwaway alias, and a defendant now facing sentencing, bond conditions, probation requirements, and a backlog of warrants that keep piling up. The court set the bond at $5,000, 10%, with conditions including no alcohol or drugs, 30 job applications per week, and mandatory warrant clearance. Sentencing is scheduled, and the reckoning is coming. Fear is understandable, but it doesn't get to be an excuse, not in this courtroom. Not in any courtroom. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns. Because justice never gets old.